Hello, my name is Renee Castillo de la Cruz, and I'm the Children's Commission's Trial Skills Training Course Director. The following lecture on how to create your CPS trial notebook is presented by Ms. Michelle Surratt, Managing Attorney for DFPS Region 9, and Mr. Rob Galvin, Attorney at Law. I now turn it over to our presenters, Michelle and Rob.
Hi, I'm Michelle Surratt. I'm the Managing Attorney for Region 9 for the Department of Family and Protective Services. And I'm here along with Rob Galvin. I'll let him introduce himself.
Hey, I'm Rob Galvin. I don't manage anything except myself sometimes, but I've been practicing this area of the law for the last 22 years. And so we're here hopefully to provide a little bit of information and help along the way.
So what we're going to talk about is a trial notebook. And I think the most important thing and reason that you want a trial notebook is to be organized and to have everything there available when you get ready to go to trial. So these are very good tools in jury trials, but I would also suggest that even if you have a highly contested final hearing that's a bench trial, that you probably want to go ahead and have your own CPS trial notebook for that as well. Whether you represent the state, the child, or any of the parents, the notebook is going to help you.
I would agree with that. I mean, we are looking at this as a trial notebook, but quite frankly, even a 2-hour evidentiary hearing, you should have a notebook. You should have everything put in there. If you've got a lot of case law and things like that you're going to rely on, you may want a separate case law notebook, make one for the judge, have one tab for the judge so you can hand that over. At the very least, it'll make you look very professional, and the court would appreciate that.
And I start mine from the beginning. I mean, I usually start my trial notebooks as soon as I'm filing my petitions, getting back the orders from the court. And then when I go to trial, I make it a little bit more narrowed as to what I exactly want to take to trial. So, because sometimes I have 5 or 6 volumes worth of information when I actually start going to trial. So I think what we're going to do is just give you some examples that either I've used or Rob has used for different tabs that you might have in your notebook. But first and foremost is you want to have some kind of information sheet. Just with the information on there, like the style of the case, who the kids are, who the parents are, dates of birth, those kinds of things. Are there other parties involved? And then that way you've got one sheet that you can look at real quick to figure out all the names of the parties and the children, those kinds of things.
Yeah, the one thing I would advise is that this information sheet, I mean, hopefully you're using some kind of data system at the office that has all this information. But if you have staff, make sure they have this available too. There's been a few times in the past few years or 20 years where stuff has happened on the road. I do travel some to various places. I've had an airplane land on the highway I was on that caused a delay. So strange things have happened, right? And so sometimes trying to find like the court coordinator's phone number, it can, it's hard to do when you're driving or whatever. But if you can, contact your staff and say, hey, look at that contact sheet, contact the court coordinator, the judge's office, et cetera, things have occurred. So make sure somebody has access to this information and contact the client because I'm here and they're not here, and so that might be, helpful.
And even opposing attorneys, I just took this managing attorney job about 6 months ago, and it's kind of new attorneys that I'm dealing with, and I'm often, trying to look them up on the bar website. So if you have something that, some kind of information sheet that includes all of that, it's right there at hand. And if you start that from the very beginning, then it's something that you'll always have instead of waiting until you get ready to go to trial. So this is a good thing. This is a good tool to have in every single one of your cases, regardless of what direction that it's going. Even the clerk and the judge and the judge's coordinator.
Yeah, definitely. You can't have enough information. And I'm going to reiterate what Michelle said. This is really a process that starts at the very, 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 very beginning. I think we may get to another slide that talks about like settings and things like that you can actually plug in, but you should have some kind of template where we don't use, recently in the last 2 years, we don't use written stuff much as many more because we've been doing a lot of stuff virtually, but there should be a place where, you can write down the next settings and have all that information located within 1 or 2 pages at the very beginning. Really should be the very first thing in your notebooks. So this is dealing with the cast and the chronologies. I cannot, from my perspective, I can't tell you how important cast and chronologies are for me. And this is part of my upbringing in the law. My first, clerking for Broada Spivey many years ago, I was responsible for doing cast and chronologies, and kind of the rule of thumb was if a person's name is mentioned somewhere in the case, it's important for them to be there, because the last thing he wanted was for a name to come up that he has no clue who that person is. So I use cast quite a bit, and I break them up into sections depending on who I'm representing and where these people are plugged in. And chronologies really are, for me, extremely, extremely important. I won't say misplaced, but I left my main trial notebook in the car one day and didn't have time to go back. And I spent the full day of doing cross-examinations based off my chronology, because I had that in the smaller notebook that I was carrying with me. And I didn't have my witness sheets or anything like that, but I had my chronologies, and I was able to take a highlighter for each witness and highlight the different blocks within the chronology and on the points that I wanted to address during the course of their testimony. So and these are things that start at the beginning, right? Don't wait till the last moment. For you folks that do this kind of law, I guess everybody does this kind of law. We get this, these DID files, right? The CPS case file. I can't tell you how important it is to go through those files and find people that are in there and put them in your cast and put the dates and your chronologies in there in order to be able to condense 1,000 pages or more of information into a small chunk that you can look at like that and be able to rely on.
I always have my caseworkers do a chronology for me, and they hate me. No, I don't want to. And then they love me afterwards because they're ready to testify, because they've put all of those things in some kind of timeline, detailed events of what's happening. And it's very important coming from the state side or from the department side, because you want a list of those visits, and if those visits were made or if those visits were missed. You want a list of the services and when they performed them. You want a list of those drug screens. Did they go? Did they not go? And so if you have those chronologies right there, it's very easy to pinpoint that when you're getting ready to question your caseworker, or even when you're getting ready to cross one of the parents, because you have all of that information in one chronology, one little timeline. And so it's very helpful coming from the department side as well.
Yeah. So one of the things that we talk about here, just very quickly back on the chronology stuff, is having sub chronologies or smaller chronologies. And kind of an example we use on that's on here is drug screens. So as a parent's attorney, I have a master's chronology, right? But I may also want one that's a lot smaller that just highlights the drug screens. And I've had that before where, a case that's lasted a couple of years, you're looking at it and you've had, 45 different drug screens, UAs, hair follicles, and there might be 1 or 2 positives in there. And you can kind of look at it and go, okay, well, where are the inconsistencies? Where are that some of the hair follicle, exams overlap the positive UA, and why was that hair follicle negative? And so it allows you to see things that you normally, just will get lost in the mix. And then ultimately, what's beneficial about that is that when you're cross-examining the caseworker on the drug screens, it lets you kind of walk through there and illustrate that, yeah, there might have been 3 positives that you're worried about, but there's a couple of hair follicles that overlap that were clean. So explain that. And then, out of the 3 in 18 months, he's done 57, drug tests. So 3 maybe positives out of 54 cleans, might be a very good visual that you're able to expound on in front of a jury or even a judge.
So another section that you might want to look at is, different kinds of checklists. So coming from the state side, You may want a checklist for your termination grounds that you're going to use, maybe even the individual things that you have to prove in the termination grounds. You know, if you're trying to prove failure to do services, to make sure that you have the correct amount of time that the child was in care, that you have the court order that ordered them to do that. Just make sure that you have all the elements that you need. And so if you have your termination grounds, then you would probably also want your best interest grounds as far as a checklist is concerned, just to make sure that you're proving everything up in court. This is a good checklist to go by. I also give these best interest and termination grounds to my workers so that they know what we're trying to prove in court. And it's helpful for them too, because they know what you're going to ask them. You know, hopefully you've had time to prep them ahead of time, but they know what you're going to ask them about, because these are the things that we're going to be proving when we go to court.
Yeah, I can't think of a time that I've not done a checklist, especially on the grounds and best interest. I don't carry the burden of proof most of the time because I'm representing the parent. However, I've got to understand the strength of the other side's case in order to understand the weaknesses of my own and my own strength. So I have an element checklist for every particular ground that I think the department's going to try to go forward on. And then I, have a realistic examination of what the evidence shows and how they're going to be able to prove that particular element of that ground. And is there a place where they're really weak at? And is that where I attack the ground is element number 3, right? And so is that where I looked at, we need to spend our focus on and trying to go after or trying to defend against that particular ground. If there's a ground they're really strong on, I don't want to waste a lot of time on that. And then I don't want to lose credibility with the jury that I'm trying to make an argument, that doing something horrendous to a child, like shooting their mother while the kid's in bed next to her is not, an endangering act. I may be looking at a course of conduct issue instead, right? So those are the kind of things that I think the elements are really, really important to look at. And I, pay attention to the supporting law that exists also. So if there is case law out there that's going to support your position, have it ready. And so when you're arguing, in your pre-trial hearings or you're arguing on your jury charge, et cetera, conference, have law ready to go to make those arguments that you think that are supported by what the case law has told you. So in the trial objection list, there's stuff that the other side's going to try to bring in that you can object to, but more importantly, there's stuff that you may want to bring in that you're worried you're going to run into some form of objection. So then spend time trying to figure out, how can I overcome that objection? What are my, what are my exceptions to the hearsay rule that will be applicable in this, this particular situation? So I think these checklists are extremely important to help you navigate your case and kind of shed true light as to where your case is at.
And along also this is a good place to maybe put your predicate checklist. If you know that you're going to have to lay a foundation to put in a video or to put in a recording or pictures, and you want to make sure that you get the right wording, make sure you have that you have the predicate checklist, because you don't want to not get something in just because you failed to say the words such as, fairly accurately depicted the scene at the time or something along those lines. You want to make sure that you're laying the proper predicate. And so have those things. There are some organizations out there that create these little booklets that have like almost all the predicates there. So you can use those as well. But this is a real good place for that. And I agree with Rob about the case citations. If I know I'm going to use, for example, police reports, which can be admissible into civil trials, into our trials, I have 3 or 4 cases that agree with my position that they come in, they're not considered hearsay. And so I have those with me if I know I'm going to use that specific, specific police reports as a business record so that I can get those in. So you want to make sure that you're prepared and you're not trying to dig real quick or just come up with something if you know it might be contentious when you get to trial, what you're trying to put into evidence. Okay, Rob.
Yeah, so indexes and putting things in order. So pleadings index that talks about everything you have. This gets a little. We've talked about multiple notebooks, right, in volumes 1s and 2s and stuff like that. So in a CPS case, you have a lot of pleadings, a lot more than you would in the vast majority of other civil litigation, because you've got court reports from CASA, CPS, you've got all the motions, you've got further temporary order motions. So there's a lot of stuff that's in there. So you want to start your pleading notebook at the very beginning, and the very first thing that comes in, you get in there, right? I save everything, on an electric file, and it's all numbered 1, 2, 3, 4, 5, 6, all the way down to the very last thing. And it's easy for me to tell my, paralegal, hey, make sure we've got everything that we need in the notebook that's contained within this, this folder on Dropbox. So you definitely want to list that. So what happens sometimes is, what do you do with a trial notebook when you have, 45, 99 pleadings? Do you need all that in your trial notebook? Well, you need it in your pleading notebook, but you might just need the live pleadings that are the important pleadings that are there. That's the request that's before the court. And it's also oftentimes, I've got an appeal right now where that was an issue. What was requested by the pleadings wasn't necessarily what was tried, right? So it's an important thing to have. And so I think I condense mine to the live pleadings. And then I have a separate tab that has all my pretrial motions, because those are things that are actually going to be discussed within that trial. So it is within that trial notebook. So any orders that are important to the issues that you're in front of, clearly have all your orders. That's part of your pleading notebook. But there are particular orders that you care about and you want to bring forth, have those ready too. The department may be using those orders as an exhibit, right? They're trying to prove that a parent didn't comply with the O ground, right? And so they're going to say, hey, this was the service plan, these are the orders that were done. But it's important to have that there too. So make sure you have whatever orders are necessary within your notebook.
So also you want to make sure that you have your exhibits ready to go. So that's probably going to be a separate section in your notebook. And actually, I usually have a whole separate notebook or section for exhibit. I mean, I have something totally separate for my exhibits. I'm real anal. I put them all in these little sheets or keep them nice and clean and all of that, so that they don't get messed up. And then I keep my copies with them so that I can hand them out. But you want to make sure that you have a good list as well. And I think we have some examples after this, but you want to have a list of your exhibits. You want to have like who's going to be your sponsoring witness, and then offer admitted, so that you can keep track of, make sure that you've offered them. Because there have been a couple of times I've gotten to the end and I'm like, oh, can I reopen? I didn't offer exhibit 4, 20 minutes ago. And so if I have that checklist, then I know that I've offered, or I need to offer it, and if it's been admitted, because you want to make sure that you get a ruling from the court to have those things admitted. The other thing is that you want to make sure that everything is marked, pre-marked, and give that list to the court reporter. They'll be eternally grateful for any kind of list that helps them out as they go. But if everything is pre-marked and ready to go, it gives you, it's a lot better for you moving forward. And nowadays with virtual court, you're actually having to send those out to everybody. And so it's kind of made me better in getting everything ready, because a lot of times I'd wait till the last minute, mark everything and trying to get it all going. Well, now that you have to send them out, 2 to 3 days ahead of time, depending upon your court, you're having to get all of that ready to go ahead of time.
So the only thing I would add to that is, I think we're going to get into a couple of examples here, but know your local rules, right? So that's really important. Some places require an exchange of exhibit list prior to your settings, depending on what the setting is also. And then, every judge wants a copy of your exhibit list. So be prepared to hand over a copy of your exhibit list, and try to get a lot of this stuff done via pretrial. And so I think courts appreciate where you can have the discussion of these are the exhibits that I'm planning to introduce. These are the exhibits that we agree to. And then these are the exhibits that, we need to fight about. So, so yeah, just be prepared and, know your local rules as to what your particular court requires and what they're going to expect from you when it comes to having those exhibits.
And these were just a couple of examples of exhibit lists there.
So this one right here is like the one that I would normally do for exhibits that go to the, you need a ruling from the court. So this is what I would give the court. And, is it offered? Is it agreed? Is it admitted or is it denied? And that's kind of the exhibit list I would run through at the trial. The one before that to me is a really important exhibit list because it talks about the, who's going to sponsor. So there's really like two lists, right? The court doesn't need to know who's going to sponsor that particular exhibit, but I definitely need to know who's going to sponsor that particular exhibit, right? So, looking at two different lists, serving two different purposes, though a lot of overlap.
Yeah, this is what I use for myself, is this particular list, and I have everything listed. So in my person, and then I just have to worry about the offer and admit when I'm actually in trial. Okay, so you might have a tab regarding business records, and you might create yourself a log. So if you use a lot of business records in your particular case, such as medical records, maybe you have a child that was born addicted to meth or had meth in their system. Maybe you're going to use some law enforcement records. Maybe you're going to use some records for therapy for the kids or the parents. And so you want to make sure that you're keeping a good and accurate log of where the business records come from. Have you received it back? Have you sent it to the attorneys? Because remember, now you have to send those directly to the attorneys 14 days ahead of trial. You send the actual record with the business record affidavit attached to it. So you want to make sure that you're getting those back and that you've sent them out in plenty of time. So be sure to keep yourself a log and then have your business records. You can either keep that like in your exhibit tab, or you can even have a separate tab for your business records, however you feel more comfortable.
So we get to the voir dire process, right? So in the notebook, you're going to have a section that deals with voir dire. And so a tab, and, in your voir dire section, you want to outline your case, what the theme of the case is that you're trying to show, and kind of, outline what the voir dire looks like. My voir dires really are bullet points. I don't necessarily write questions. I really don't. Maybe once or twice I might have written one or two questions, but normally it's just these concepts that I want to talk about, which are tied into the theme of what my case is, and how can I get to a point to kind of educate the veneer panel as to what my case is about without talking to them about the facts of the case, right? So that's important. If you can get a seating chart, great. And so a lot of times, you try, you do a little bit of investigation, right? It's like, what courtroom am I going to be in? What do the seating charts look like? If I have no clue where I'm going to be, I might just have a bunch of boxes, a graph with a bunch of boxes, and I'll make it up as I go along because I don't have that information ahead of time as to what the seating chart is going to do. If you're going to do a motion to reshuffle, I would have one prepared and ready to go. I think once in my life I've asked for a reshuffle. So I don't do that very frequently, but you want to have it ready in case you need it. That's one of those rare things that you may need, but better to have one ready to go in your trial notebook in case that happens and you're not trying to write it out on the yellow pad. So that's what I typically have in my voir dire section. I think there's some stuff, from where I practice mainly, we don't get a lot of information about our potential jurors, and we get their packet typically hour or two before jury selection. And a lot of times we're not allowed to take them out of the courthouse. So, I don't know how the TV shows that have these jury folks, I don't know how that works, because that's not been my experience, that you have all that time to try to figure out, anything. Just try to be prepared as you possibly can, and kind of stick on your big concept themes that you want to cover and the kind of jurors that you're looking for.
Yeah, Rob, I don't guess you or I are going to be able to hire Bull for our jury selections. um, a lot of times I travel all over the state to do jury trials, and I haven't ever been in these courtrooms. So sometimes I'll reach out to the court coordinators. They might have a seating chart already, or even the county attorneys or district attorneys in those areas, because they try cases in there regularly. And so you might try that too, just to get that panel seating chart. I will say I've been seeing lately a lot more, and maybe in other areas this has been going on a while, PowerPoints on your voir dire. And actually that way you've got your little bullet points on your PowerPoint and able to cover your points that you want to make.
Hey, so Michelle, can you tell us, like, if you want to use a PowerPoint in voir dire, what is it that you do prior to the voir dire process in order to make sure that that's okay with the court and you're not going to get an objection from the other side?
I usually just make sure that it's available. Most of the courtrooms have really upgraded a lot, and so those do become available. They have the a lot of them have the screens in there, and you usually will have to bring your own flash drive and or hook your computer up, make sure that you have the correct cables. I've had to bring my own cables before to hook up to in order to do the PowerPoint. I have not ever had anybody object because it's just demonstrative as far as the PowerPoint is concerned. I usually try not to put anything in there that, like pictures or something like that, that might be objectionable. It's just more like bullet points. This is what I want to cover. And it helps me stay on track without looking down at my piece of paper and then looking back up, because it's all right here. I can, this is my next thing I'm going to cover. And then I can go to the jury panel and talk to them about that. Do you have some specific things that you do, Rob?
No, I mean, I typically will show it to the other side before I use it, right? And and I have a discussion with the court, always trying to be cognitive of what that particular judge in that particular courtroom is willing or allowing to happen. So yeah, I've never really had an objection to that, because not like with you, I kind of stay with what the law is and stuff like that, and not try to put evidentiary stuff in there. But yeah, I was just wondering if you had a different approach, but I kind of like to show as much as I possibly can, and then a little bit more, and have really, really clean hands when it comes to this kind of stuff. This is what I intend to show. Do you have a problem with it, opposing counsel, and then see what they have to say? Because the last thing you want is you start your voir dire and you hit your clicker, and then somebody jumps up and objects, and you're in front of the bench, and then the judge says you shut it off, even though you think that you have the right to present it. He who wears the black robe makes the rules, right? And so then you are shutting off your PowerPoint, going back to the veneer panel going, hey, well, let's talk about some other stuff, guys.
Yeah, I guess make sure you have a copy of it in case that happens, so you still have your information there. I used to have these big old boards that back in the day, Trevor Woodruff had made at like Kinko's or whatever it was called back then. And we used to use that because a lot of the rural courtrooms that I went to didn't have capabilities for to use PowerPoints and things like that. And so we would just get these cardboard things and hold them up, and it lists the termination grounds or the best interest grounds. So really come a long way with voir dires and the things that you can use on voir dire in moving forward. So you want to make sure that you also have that you have a section in your notebook for your jury charge, and you want to keep that charge on some kind of flash drive, because a lot of times what will happen is the court will ask for that, and so you want to make sure that you can hand that over. A lot of the judges that I've been dealing with lately are wanting that even a couple days before we start trial, is a proposed jury charge. what I have found too is when I start doing my jury trial, it really helps me too with preparing my checklist, getting ready for court, because I'm putting the termination grounds in there. I'm putting the best interest grounds in there. You know, what do I have to prove? And so it really does help me with my checklist. It helps me with my voir dire. It really helps me with my trial when I start working on the jury charge going forward.
Yeah, I would agree with all that. You know, that's the adage, right? You start at the end and work back in trial, or in any case, what's your charge going to be? And then you kind of move backwards and you start with your charge, the very first day you've got your case, right? Typically not the very first day, but early on, you get kind of that understanding, and that moves us all the way back to those element charts and everything else that we were doing there. It all ties in together. So yeah, definitely have your proposed charge ready to go. A lot in Travis County, for example, I think it's 10 days. I may be wrong on that. But we have to turn in our proposed jury charge prior to court. So have that ready to go. And one of the things is, have a charge that you believe in ready too, because at some point you're going to have a charge conference, and you may disagree with the charge the way it is. And the only way for you to preserve error is to turn over your charge to the judge and say, this is what I think needs to be the charge. And if you're going to reject it, just write reject on there and file it, please, so I can preserve my error.
Hey, Rob, so do you do your own charge, or are you required to do your own charge? Because in a lot of my counties that I practice in, the attorneys for the parents or for the child will usually look at my charge, and then they'll make suggestions for additions or deletions, basically based off ours.
Yeah, so normally I do my own charge, and so I can't think of a time that I have not done my own charge. Maybe if I'm an attorney ad litem, I haven't done a charge and I've looked at what the department's put forward. If I'm aligned with the department, or I've looked at what the parents have done and I said, I think we need to change this, we need to change that. But I typically have my own charge. I mean, it's really just out of the PJCs. I'm a big formatting freak, and so sometimes I like to mess with formats and stuff like that. But yeah, I typically do. Now, at the end of the day, it is if it's an agreed charge, it's a combination of people working together to come to a common, yes, we can all agree that this is the charge when we have our charge conference. But there have been a few times where I've disagreed with the language in the charge, and the courts try to move me in a certain direction, and I'm like, I just don't think I can get there, judge, and I think this is what it should be. And so I'm objecting to the charge at the charge conference, and here's my proposed charge, and reject it and file it for me, please.
Yeah, make sure you have copies for everybody. Sometimes the court will make copies, but you want to make sure that you have those copies, or that you're emailing them to everyone if that's what's required. Rob?
Opening statement and closing argument. So a section in the notebook that deals with your opening statement and your closing arguments, stuff that you need to start thinking about early on in preparation for trial, not necessarily early on in the case, but as you're getting you're a month away, you're gearing up and you start thinking about the case. What are the big points that you want to hit? And so what I'd normally do is I have a section that says opening, closing, and I've got 1, 2. One's for opening, 2's for closing. And I have blank sheets of paper in there initially, and I start writing through there as I'm thinking about the things that I need to bring forth. By the time I get to trial, the opening part's been done, right? The closing part, although I've given it some thought, really hasn't been done. And it's during the actual trial that I may go back and open that section and start taking notes down in there that someone has said something in the course of trial that I'm thinking, I'd really need to use this in closing, or there was a particular point, or there was a piece of evidence. And so I start jotting notes in there. At the end of the day, I may take my yellow tab, and in the course of trial, I've used a particular marker to highlight parts of my yellow tab that I think are important to remind it. So what is a closing argument? It's reminding the jury of points that you think are important for your case, right? And so I may go back to my yellow pad and look at those highlights and then transfer those over to the section where I have my closing. The reason for that, and it's redundancy to some extent, but there's nothing worse in the world that you're getting ready to go make an argument and you're like, okay, I know it's in this particular notebook. What did Jane say? Where's it at? I can't find my notes. And that's for me, the worst feeling to have is that there's something there. You just can't figure out where it's at. So that's why the redundancy of, I'm going to take it from this yellow tab and move it over. If, worst case scenario, photocopy the yellow tab, punch some holes in it and stick it in that section there. So hope that made sense to y'all, but that's how I do it.
I work very similarly. I highlight, and then like at the end of each night, I might move it over into that little closing statement, those pages that I'm using for my closing statement. But the other thing besides your opening and your closing is you're going to have witnesses, and you're going to have information on your witnesses, and you want to keep a little sub tab for each of your witnesses. So you want to have information regarding, if they have a resume or a curriculum vitae, you want to keep that if you're dealing with expert witnesses. If you have any kind, if they've done a report, maybe you have a psychologist or psychiatrist, you want to make sure you have their report with it, grouped with that in their sub tab. If they're a therapist, if you have any notes from prior testimony that you can use, if you've cross-examined the parents before and you might have some notes about that, you might want to keep that with your witness sub tabs as well. But you want to make sure that you have the information on your witnesses, where they serve to be there, kind of what day and time do you think that you're going to call them. You want to make sure that you have a little log for your witnesses and keep those sub tabs for each witness.
Yeah, so one of the things with witnesses that we run into, and we'll get into some examples of like a witness list and kind of the information that you put in there. So for me, a lot of times my trial notebook will consist of 1 to 2 pages for each witness, somewhere in that neighborhood, right? It might be an outline or bullet points of their direct or cross-examination. It might be all their contact information and how to get a hold of them and all that kind of good stuff. I use exhibit boxes. And so, early on, I try to put everything in the notebook. And I had these big 3-inch, 5-inch notebooks, and they were really heavy and stuff. And so for me, when, if I've got someone that's got a 20, 50 pages that they're going to sponsor and it's part of their deal, and my reference and my witness summary is to that exhibit box and that exhibit tab and number, so where I know I can go find what I need for them instead of trying to put everything inside the notebook and making it way, way, way too big to deal with. So that's how I use it. So most of them, like I said, 1, 2, maybe 5 pages if it's not a lot, and that's that exhibit that's going to come from there. But normally it's kind of a summary of who they are, how to get a hold of them, and if they have any other evidence that they're going to sponsor or I'm going to use against them, because that might be part of it, right? From my end of it, I reference that so I can look at witness tab 13, John Smith, exhibit box 7A, whatever, that's a tab I'm going to, and quick note of what I'm going to do with 7A.
And here's a little example. I think this is Rob's example of his summary, and then oops, let me go back. And then this is another little example that you could use to try to make sure that you're keeping your witnesses straight. Okay. Rob?
So we got our trial logs. So I guess with the trial logs, what I look at is it's information gathering, right? That's kind of what it works to. So it's looking at this and saying, where do I get the information for this trial? My kind of take on it is, unlike a lot of cases that we do, our discovery, I'm not saying it's limited to, but it's 80% of it, maybe if not more, is within that CPS case file. And so a lot of what I'm looking at is trying to figure out where in the logs all this information is. And I'll give a really quick story of why I think some of this stuff is important. You know, there was a case I tried many years ago where I was an ad litem, and you know, I got part of the logs and looked through mom's medical records, and she was at this, you know, really expensive drug alcohol treatment program, and her issue was she was an alcoholic, and really, you know, she was kind of like mom of the year when she wasn't drinking. And she fooled all of us. You know, we were all like, oh, the kid needs to go back, and, you know, this and that, right? And then she ended up at the, you know, getting hurt, falling down the stairs when she was at home with the kid by herself. And she blew a 0.34 when she went, because she busted her chin open when she fell down the stairs. And so I'm working through some of these logs, and I see the facility that she was staying at, the doctor's logs of the daily, you know, check-in on her, and they're boring. There's nothing in there. You know, what are you gonna get? Temperature was 97 point, you know, this and that, you know, daily logs. However, on a Sunday, it read, I saw patient early today because she's got court Monday morning. And I went, court Monday morning? What the heck is that about? Because our courts are on Wednesday in that particular county. What is this court Monday morning stuff? Turns out that she had court Monday morning in Galveston County for her third DWI that we knew nothing about. But we never would have found out about that, but going through the logs and going through and trying to figure out where it's at. Clearly, at that point, you know, that log became really important, and it was cross-referenced all over the place. So I know, make logs for, you know, look at those visitation logs, the service providers. I mediate cases, you know, and I just mediate a case, can't talk about anything that happens to mediation, but no one knew what the services were, right? I mean, no one knew that, you know, I go to mom and going, well, you know, you haven't done your services. And she's like, I've done all this stuff. What are you talking about? How did they not know this? They pay for it. And it turns out she was right. And so it changed the trajectory of that mediation very quickly. And that's how I spent my morning. So yeah, so logs are important.
Yeah, and I do a log for everybody, you know, at least all the parties for sure. Each parent, mom's boyfriend, dad 1 through 18, how many ever you have. And then I also do one for the children, because a lot of times you'll find interesting information in school records. If you have school records, if there's issues with them getting to school. And so I also try to put the children in their own tab. If there are people that are a big part of the case, like a boyfriend, a girlfriend, a stepmom, stepdad, I may even make a tab for them, because a lot of times I've had cases where, you know, mom is continually dating somebody with criminal histories or criminal histories involving domestic violence. And so if I could show that pattern, that's a continuous pattern. So I want to make sure that I have information on them as well. And then I think here towards the end, you want to make sure that if you have issues with discovery, if you get served discovery, or if you serve discovery, that you have some kind of log for discovery, because you want to make sure what you've requested, when you've requested it, or in our case, when we've responded to it, when we were served, and then when we responded to it, to make sure that you have all of the information that's been turned over, and that's been turned over timely. Or if you need to object to that, you want to make sure that you have the answers to that discovery so that you can make objections in court. Rob?
Yeah, so I think the only thing I would add to that is, if some of you are coming onto a case late because you're substituting in for whatever the reason may be, make sure that you take a look at the discovery responses that have occurred prior, and make sure that they're up to speed. It's happened to me. I've been brought into a case to try a case right before trial, and then I was left alone to try the case. And you know, then I get into this issue. Well, you know, the discovery wasn't responded to, or this particular person, this witness, wasn't listed. And so you get into those kind of, you know, situations where you have to pay attention to your disclosures. And some jurisdictions have their own discovery control plan. And so they're very, limited, and you have to go get leave of court to do what, anything else like you normally would do. Others just have open discovery under the TRCPs. So, pay attention to that situation. I mean, the worst thing for you on the parent side is to be wanting to bring in a witness and Michelle objects, even if it's mom's therapist, but because I didn't list her as my witness, right? Or I didn't list her as an expert to testify about things that, a therapist expert opinion would testify about, right? And, I could be arguing till I'm blue in the face. It's not unfair surprise. They knew about this person. They actually pay for her. They told her to go there, all that kind of stuff. But the judge just has great discretion and then says, no, I'm not going to let her testify, or she can't testify as an expert. And, because you didn't list her. And I think that's the right response, right? We read the rules. And so then my client's looking at me going, what did you just do to me? So, it's important. Take a look at the discovery stuff. Even in these type of cases, discovery is important, even if there's a discovery control plan.
And this is just an example of a log that you can keep if you want to do that, to make sure that you've answered or that you've sent whatever it is that you need to do. So that's the end of our PowerPoint. I just want to close with, trial notebooks are to help you and to help you be organized when you go to trial. And then you're not constantly just trying to filter through boxes or notebooks looking for something. And so whatever kind of notebook you do, whether you follow some kind of guideline that Rob and I gave you here today, or you create something of your own, it's just a good tool to have. And it's good to start it in the beginning.
I would completely agree with that. And, I've heard this a lot from various juries. I heard this from a Harris County juror one time after trial, is that they leaned in our direction because we were so much more prepared than the other side, and thought that we took it a lot more serious than the other side, because they were always trying to find things, and there was always long delays between questions, or trying to pull up an exhibit and pulling the wrong thing up and stuff like that. And I think we would have won on the merits anyway, but at least to that particular juror, it was important, and for them, that the attorneys for that particular client were more prepared and ready to go. So it seemed to mean more to us than it did the other side. So, that's the trick of it is, if when you're trying jury cases, you want them to like you. We want them to say, if I needed to hire a lawyer, I think I'd hire that guy. That's what you want, right? And so you kind of get there by being prepared, and that's what the trial notebook's all about, is keeping you prepared and keeping everything where it needs to be at a minute's notice, so you can pull it and refer to what you need to refer to. So thank you.
Thank you both, Michelle and Rob, for that wonderful presentation. And thank you to our participants for watching this video. We look forward to seeing you at Trial Skills soon.